This is David Sandbeck with Minnesota Spectator News, and there's a story out of the Minnesota Reformer reported by Max Nestrick, written by him, and we're going to get into it here shortly. It is about the what I call wage theft that's happening, and Target is participating in the rule and is no exception to this wage theft. But let's get into the story. Target Corp has quietly settled half a dozen class action lawsuits and still faces two more from workers who allege the company has failed to pay overtime they're owed. Target calls these workers executive team leaders and pays them managerial salaries as opposed to hourly wages. That keeps them from earning overtime. But the workers say they're worker bees like other Target staff, restocking shelves, hauling garbage, and bagging groceries. In legal filings, workers say Target regularly requires its low-level managers to work 50 hours a week or more because they don't earn overtime. While rank-and-file workers, hours are closely monitored and kept below full-time. Richard Harbour, a Connecticut attorney who filed the case, said he doesn't think they're executives. And he filed this case in federal court in Minnesota with the Minneapolis-based firm Nichols Castor. He goes on to say, I don't think most people who hear the word would imagine someone who unloads trucks and stocks shelves and moves merchandise around a huge retail store is an executive. Haber's client is Andrew Davis, who worked in a store in Connecticut and claims he had very little managerial authority and spent most of his time doing the same tasks as hourly workers. Haber declined to make Davis available for an interview, but you can read Davis's complaint online. Target has yet to respond to the most recent lawsuit in court, but in an email, company spokeswoman Jenna Reck wrote, we have a long history of investing in our team and providing them with industry-leading wages and clear roles and responsibilities for their work at Target. We are aware of the lawsuit and confident that our executive team leaders are appropriately classified as exempt employees given their management responsibilities. The stakes could be significant for both Target workers and the company. If either lawsuit is successful, Davis and the plaintiff in a parallel case, Priscilla Jabau, could win back pay for themselves and thousands of executive team leaders going back up to 3 years. That would likely cost the retailer tens of millions of dollars, although lawyers in both cases wouldn't speculate just how much Target would owe. You can read more about that complaint. JIBOWU is the name of the plaintiff in that complaint. But so far, none of the 8 class action lawsuits has overcome the most significant hurdle, convincing a judge to approve bringing the case on behalf of all executive team leaders and notifying them of the lawsuit. The cases have all been brought under the Fair Labor Standards Act, signed into law in 1938 by Franklin Delano Roosevelt as the country was digging out from the Great Depression. Delano had called this a landmark piece of legislation that established the minimum wage, a 40-hour work week, time and a half for every hour worked beyond 40 hours. And Franklin Delano Roosevelt is quoted as saying, except perhaps for the Social Security Act, it is the most far-reaching, most far-sighted program for the benefit of workers ever adopted here or in any other country. He said that on the radio the day before he signed it into law. This law was designed to provide a more humane work environment and increase employment. Think about that now at a time when 40 million people are out of work. This is a simple way we can increase employment by enforcing the laws we already have on the books. Let's get back to the story. By forcing companies to pay more for more than 40 hours of work, the businesses were more likely to hire additional workers while also increasing the income of workers who toiled longer. But the law explicitly exempts certain workers from its protections, including managers who are not entitled to the overtime pay no matter how many hours they work. Companies are allowed to claim their workers are exempt from overtime pay if they regularly direct the work of 2 or more employees, have the authority to hire and fire workers, and earn a minimum salary set by the federal government. $35,568 a year as of last fall. While these exempt workers are allowed to do the non-management work under the law, their primary duty must be to manage. In Target's hierarchy, executive team leaders are the lowest ranking managers. There are as many as 14 in some stores, and they specialize in departments: technology, groceries, human resources, among others. In each of the lawsuits, including Davis's, former Target employees claim they had virtually no managerial authority when they set up salaries, when they set up sales displays. They did it according to corporate instructions. When they set out work schedules, they followed a computer algorithm. When they wanted to hire or fire another employee, they did it only within the permission of store managers. Executive team leaders must even check off tasks that are recorded in a central computer system, according to one plaintiff. There's largely just a following of orders and carrying them out, Haber said. For retail workers whose starting wages are typically minimum wages, management jobs offer an opportunity to climb the lower rungs of the middle class with steady pay, health benefits, and even a retirement account. For big retailers where wages are typically the largest expense, hiring salaried assistant managers to work 50, 60, 70 hours a week and avoid paying them the overtime offers massive savings. That's why so many retailers do it, and so many workers accept it. For its part, Target pays higher starting wages than many retailers. It plans to pay all of its hourly employees $15 an hour by the end of the year. How generous. But that could also make limiting the hours of those workers and leaning on executive team leaders to make up the difference all the more valuable. As common as it is for the retailers to use this strategy, it's also illegal if managers' primary duties aren't managing. When companies violate a law over and over again, it becomes a standard operating procedure. It doesn't necessarily mean they're not all violating the law, says Haber. The Connecticut attorney who built a career on suing companies for unfair labor practices. In 5 previous cases, Target has been able to persuade the plaintiff to settle for themselves before judges decided whether to certify the cases as class actions. In 2010, Target settled a case in Minnesota with 10 former executive team leaders for an undisclosed amount. In 2012, they settled in Florida with 2 workers for $22,000 in total. And in 2015, they settled in Texas with 2 workers for $15,000. In 2016, they settled in New Jersey for 2 workers for $83,000. The next year, they settled in Arkansas for an undisclosed amount. In one case brought in the state court in California in 2004, a judge decided not to certify the class, ruling that workers were not similar enough for the case to be brought on behalf of all executive team leaders in the state. Target is not alone in facing these allegations. Most big box retailers have been the subject of lawsuits alleging they've claimed worker managers to avoid paying overtime. Walmart, Home Depot, Family Dollar, Lowe's, and Big Lots have all settled such lawsuits, sometimes costing the retailers millions of dollars. Again, it's costing these low-wage workers millions and millions of dollars. That's who is really being targeted here. But let's continue. The most money employers can get when they bring these cases is what they're owed in back wages. Sometimes they can double it if they can prove their employer cheated them out of wages on purpose, but they don't win or retire to Hawaii money. Despite the relatively small amounts, the promise for a quick settlement is often more appealing than sticking it out through years of class action processes that could make all the executive team leaders whole. They decided they had to take a payout, said Fran Rudick, a New York labor attorney who brought the case in 2016, shortly after her clients decided to settle. Rudich and her colleagues filed a smear lawsuit in federal court on behalf of Jabot. That case has been ongoing since 2017. Both Rudick and Haber said their clients are in it for the long haul, and they won't settle until a judge approves their class. Eventually, Target may have to ask the two lawsuits to be combined, but for now, they're playing out simultaneously in two different federal courts. So just a summary here that, this is an abusive practice. This is wage theft to low-wage workers, and it's become commonplace. And one of the ways we could discourage that is you call your legislators and you let them know about this practice, that these retail workers are working more than 40 hours a week. They're not getting paid overtime because they're misclassified deliberately as managers, even though they're doing restocking of shelves and they're not really doing management work. And that a discouragement should be, you should support large fines, and there should be large fines that benefit these abused workers. And that's, I think, the only way we're going to stop this kind of criminal activity from corporations all over the United States. We are in the middle of a corporate crime wave in this country. I would say it's an unprecedented corporate crime wave. We're in a new Gilded Age. Both parties, both dominant political parties, are basically parties of plutocracy. So I wanted to share this story with you. Thank you for your time and attention. Again, this is Minnesota Spectator News with David Sandbeck, and take care. Remember to use that like and subscribe button so you can stay informed with Minnesota Spectator News.